Meghan Markle responds with legal counteroffensive as custody war enters new phase. London, February 11, 2026. In a stunning development this morning, Meghan Markle filed a formal motion to reassess the temporary custody agreement signed just hours earlier, launching what royal legal observers are now calling the most aggressive post-separation counterstrike the monarchy has ever faced from within its own bloodline. The filing, delivered to the California Superior Court, arrived less than 24 hours after both parties, Prince Harry and Meghan Markle, signed a provisional agreement mediated under the Windsor, California Custodial Safeguard Act. That document, intended to establish a framework of peace amid the escalating dispute, had outlined 3 key terms: 2 supervised visitations per month for each parent, restriction on removing Archie and Lilibet from California or the UK without mutual written consent, education costs to be split 60/40, Harry, Meghan. But the ink had barely dried before Meghan launched a blistering rebuttal, accusing Prince Harry of coercion, hidden royal influence, and psychological pressure that rendered the temporary terms legally suspect and emotionally punitive. This is not a parenting plan, it's a containment strategy, Meghan's lead counsel, Sherry Tilden, declared outside the Brentwood legal complex. My client has been forced into a lopsided agreement orchestrated by institutional interests cloaked in family dynamics. In the newly filed response motion, Meghan's legal team requests a full forensic reassessment of all custodial, financial, and reputational arrangements made under the February 11 agreement. The document alleges Prince Harry's behavior during the negotiations was erratic and emotionally unstable, citing a heated exchange recorded in court mediation on February 9, during which Harry reportedly accused Meghan of turning their children into sponsorship tools. Royal interference from Princess Anne and the Royal Household Legal Office constituted extrajudicial intimidation, including private briefings leaked to media with the intent to destabilize Meghan's legal standing. The financial split of 60/40 on education costs is arbitrary and unfair, given Meghan's claimed drop in net income following her effective blacklisting from commercial platforms after the Palace revoked brand privileges on February 6. The filing seeks to nullify the agreement's enforceability and demands a clean room renegotiation under a neutral third-party, non-royal mediator, preferably appointed by the U.S. Department of Child Welfare arbitration. Palace sources dismissed the motion as strategic flailing, accusing Meghan of buying time to reassemble her fractured legal and public relations apparatus. A senior aide to Princess Anne told The Times, "The protocol was activated for one reason: to protect the children. Every institution involved is acting within the scope of international legal cooperation. Meghan's team is attempting to confuse visibility with victimhood." On February 10, Prince Harry's team, led by Miles Armitage, submitted a 17-page preemptive defense, anticipating attempts to disrupt the February 11 agreement. The document includes screenshots of school withdrawal letters signed by Meghan in December 2025 without co-parental consent, evidence of Meghan's travel planning to Doha and Dubai throughout Q1-Q2 2026, with notes referencing brand visibility for Archie plus Lily, psychological testimony from a royal family pediatrician who evaluated the children post-relocation to Wolverton Cottage, noting signs of conflicting parental identity construction. Harry's formal statement today, issued through legal counsel, was unambiguous. The agreement was signed in good faith, and it prioritizes our children's stability. Any challenge to that stability will be met with full transparency and legal resolve. Meghan seeks to flip the narrative by focusing on 5 evaluative pillars: income, housing, parenting history, spousal conduct, and mental health stability. She is also invoking California-specific family statutes that prioritize maternal caregiving, arguing Harry's role post 2020 was symbolic, not structural. In a bold and controversial section of the filing, Meghan revives past allegations of Harry's substance use disorder, citing 3 incidents from 2017 to 2019 where he disappeared for hours during family events, and 1 instance of verbal aggression while intoxicated in early 2018. These claims are not new, but this is the first time Meghan is asserting them as part of a legal justification to deny joint custodial authority. Meghan's team argues that the monarchy has no standing in custodial law under U.S. jurisdiction, and demands that Princess Anne, Prince William, and the royal household withdraw any formal or informal claim of guardianship. This stance directly challenges the Windsor, California Reciprocal Accord of 2024, which Meghan's own legal advisors had once endorsed in exchange for retaining titles and brand privileges post-Megxit. The filing also reopens financial disputes, notably over Hartwell Estate, a 3-acre countryside property in Gloucestershire once earmarked in Queen Elizabeth II's private will for Harry. The $14M Montecito mansion, allegedly purchased via shared Arkewell funds, a combined portfolio of $7.8M in savings and securities, now frozen by court order. Meghan's claimed a spousal support of $187,000, month due to career disruption, linked to royal entanglement, and reputational damage. Perhaps most explosively, Meghan now contests Harry's legal authority over Archewell Foundation's digital assets and intellectual property, alleging that Harry diverted funds meant for joint initiatives into his solo project, Invictus Legacy Education. He requested Meta and Spotify to restrict login access to shared platforms without court approval. He initiated private negotiations to dissolve Archewell UK without Meghan's signature. A preliminary hearing is now scheduled for the 16th of February 2026 at the Santa Barbara Family Law Courthouse, with simultaneous amicus representation from the UK's Royal Child Welfare Office and US State Department custody observers. The world will be watching. Less than 24 hours after Meghan Markle's bombshell counterfiling challenged the February 11 custody agreement, the British royal household fired back, this time not with silence, but with legal precision. In an internal legal brief circulated early this morning, the palace confirmed it had reactivated its full custodial advisory committee and had formally appointed Duchess Sophie of Edinburgh as co-guardian in custodial transition, should the U.S. court system recognize Harry's plea for structured royal oversight. The Crown cannot afford ambiguity, read the summary. This is not a fight over privilege, it is a fight for protection. The legal brief, signed by Lord Chancellor Sir Alaric Penrose, was delivered simultaneously to the UK Family Division Court, under cross-jurisdictional alignment, the British Consulate in Los Angeles, triggering formal communication with the California Court, the Royal Household Child Welfare Committee, under the direction of Princess Anne. Meghan's rebuttal filing had claimed the monarchy was overstepping its ceremonial role. The palace's response now framed that as a misreading of the Windsor, California Custodial Treaty, 2024, which, despite being little known publicly, grants temporary dual sovereign status to minor royal heirs in cases of proven reputational, emotional, or custodial risk. In a move both symbolic and tactical, Princess Catherine made her first public comment on the matter late last night via a carefully worded video from Grey House, where Archie and Lilibet are expected to relocate under the proposed protocol. Standing in front of a children's art wall, Catherine stated, "Whatever role I am called to play, I will carry it with the grace and clarity the children deserve. This is not about inheritance. This is about innocence." The video was posted on the royal family's official YouTube and TikTok accounts, amassing 11.4 million views in the first 8 hours. Global sentiment, especially in Canada, Australia, and New Zealand, immediately swung in favor of the monarchy's measured tone, contrasting starkly with Meghan's courtroom rhetoric. On the legal battlefield, the most contentious twist came at 8:45 a.m. PST, when Harry's team filed a motion requesting independent psychological evaluations for both parties. The motion cites 2019, 2022, stress records and publicly documented disputes, Meghan's alleged media-induced distress episodes, including 2 hospitalizations in 2021 and 2023 sealed records, but referenced in Arkewell insurance filings, Harry's own openness about past mental health struggles now used in reverse to argue transparency and fitness to reform. Sherry Tilden, Meghan's attorney, immediately responded with a formal objection, calling the request weaponized vulnerability, masquerading as concern. As the battle for custodial clarity escalates, the financial front opened a new line of attack. Leaks from within, Arkewell Foundation's internal finance team confirmed that an IRS audit initiated in late January 2026 is now being formally shared with both the royal household and U.S. legal counsel. Key findings so far: MEGHAN, 1M in unitemized transfers from Archewell Foundation to a consulting firm in the UAE. Meghan's Project Emancipation Marketing Blueprint, which earmarks use of child imagery for future luxury wellness launches without co-parental consent. A delayed 2025 charity report that failed to include over $2 3M in speaking fee income, categorized as Brand Equity Advisory. The UK Charities Commission, under joint agreement with the Crown Financial Office, issued a statement this morning. Where any charitable entity bears the name or image of royal minors, it shall be subject to elevated scrutiny. This is non-negotiable. Multiple sources close to Archewell confirmed that staff morale has collapsed. 3 senior figures, including the Director of Brand Partnerships and the Deputy Legal Counsel, resigned within 24 hours of Meghan's filing. One insider noted, "No one wants to be on the wrong side of a global guardianship dispute involving sovereigns and subpoenas." Rumors also swirl that Spotify and Penguin Random House are re-evaluating Meghan's 2026 solo project, Woman Without a Crown, fearing reputational blowback and legal entanglements. As the transatlantic custody standoff between Prince Harry and Meghan Markle deepens, the conflict has shifted sharply into new legal and reputational territory, where digital identity, disputed inheritance, and internal leaks collide. What began as a battle over parenting has now escalated into a multi-front institutional crisis, dragging in the British aristocracy, Silicon Valley tech firms, and U.S. inheritance courts. At the center of the firestorm, the Hartwell estate, a sprawling three-acre royal-adjacent property in Gloucestershire, valued at £46 million, long rumored to be part of a sealed inheritance arrangement between Queen Elizabeth II and Prince Harry. Meghan's legal team now claims the estate was promised to Harry during Queen Elizabeth's 2021 private codicil, discussed in pre-nuptial verbal agreements in 2018, intended as a conjugal heritage asset to secure the future of Archie and Lilibet. On February 14 at 9:31 a.m. PST, Meghan's legal counsel filed a petition to preserve claim with the Los Angeles County Probate Division, seeking immediate intervention to block any reclassification of Hartwell as a sovereign estate, and to compel disclosure of all trust documents signed between 2021 and 2023 involving Prince Harry. "My client is not attempting to seize royal land," said Sherry Tilden. "She is merely ensuring her children receive what was once promised as their natural legacy." But palace officials swiftly rejected the narrative. A statement issued through the Lord Chamberlain's office asserted that Hartwell remains unallocated sovereign land, not subject to any inheritance guarantees, citing internal minutes from a 2022 property allocation committee chaired by Princess Anne. While legal teams prepared for another showdown, an unexpected twist emerged. Lady Louise Windsor, the discreet but increasingly visible custodian in training under Princess Anne, was spotted at Dulles International Airport, arriving under diplomatic seal from RAF Northolt. Her objective: to conduct an on-site welfare review of both children as part of a royal household directive filed under the Custodial Protection Treaty, 2024. Accompanied by 2 child welfare officers and a trauma psychologist from the Royal College of Pediatrics, Lady Louise's role is to observe, to not intervene. Yet her visit has triggered anxiety inside Meghan's Brentwood circle. Insiders say Meghan's team is refusing access to any unsupervised visitation, citing the ongoing California injunction on foreign custodial interference. Louise, however, has diplomatic cover. Her presence is not negotiable, and her final report will inform the royal family's next public guardianship statement scheduled for March 1. Simultaneously, a battle erupted over the @ArchieLilibet Instagram account, which exploded in popularity during the Sussex's 2023 documentary era and currently boasts 3.2 million followers. In a dramatic motion filed at 10:12 a.m. PST, Meghan requested full digital custody of the account, complete removal of all images featuring herself and the children from platforms controlled by the royal household, an order barring Harry from referencing her or the children in any public interviews, publications, or philanthropic appearances. Her argument: the account constitutes personal property created during marriage, tied directly to her creative labor, emotional storytelling, and personal branding. But Harry's side countered with newly leaked internal meta-documents, showing that the account was registered and maintained under Windsor Child Digital Archives, UK, a framework set up with Palace legal coordination in 2022 as part of an early attempt to centralize digital protection for royal minors. These documents list Prince William, Princess Anne, and Harry, not Meghan, as institutional co-owners, casting doubt on Meghan's standalone claim. "This is not just an Instagram account," said Miles Armitage, Harry's legal counsel. "It's a strategic digital asset, and it cannot be leveraged without consequence." As pressure mounts, the Archewell Foundation has begun to fracture from within. 3 anonymous employees submitted sworn affidavits to the IRS and the California State Attorney General's office, alleging that Meghan's private marketing team used joint funds to pay for $1.8 million in brand launches, unrelated to the foundation's mission, hid internal audits from co-trustees, manipulated child-focused content for sponsor pitches, including one proposal to license a children's cartoon loosely based on Archie and Lilibet, without legal sign-off from Harry. One former staffer wrote, "We were told it was her legacy, and she didn't need approval. We were just following a vision. Now it looks like fraud." A full forensic audit is now underway, jointly conducted by the UK Charities Commission and US Office of Tax-Exempt Organization Review. Early estimates place the potential misappropriation between $2.7 and $4.4 million USD. In the U.S., the ideological fault lines have opened wide. The View aired a heated segment questioning why Harry wasn't investigated earlier for potential coercive control. Fox News countered with a scathing panel, "Meghan weaponized motherhood. The monarchy is finally protecting the heirs." The Guardian published a front-page editorial titled, "When Branding Replaces Parenting," calling the digital disputes a terrifying omen for modern parenthood in the influencer age. Meanwhile, Buckingham Palace has maintained public silence, but quietly, institutional fortifications are underway. As the custody conflict between Prince Harry and Meghan Markle descends further into legal and reputational chaos, a new and volatile front has erupted: a war over money. At the heart of this battle are allegations that Meghan misused joint marital assets for personal branding campaigns, concealed foreign bank accounts, and manipulated insurance filings to sustain her luxury lifestyle amid a collapsing public image. Conversely, Meghan's legal team is now accusing Harry of attempting to shelter Windsor-aligned properties and funds to block lawful marital division. The financial filings delivered to the California Superior Court this morning stretched 87 pages and read more like the forensic audit of a failed corporation than the divorce proceedings of a former royal couple. The most explosive revelation: Meghan's $2.3 million in personal purchases made on joint credit lines between 2022 and 2025, including over $480 in fashion acquisitions from Hermès, Dior, and Elise Ab, $670,000 in private aviation bookings for solo trips to Abu Dhabi and Nice, $310,000 spent on image enhancement and media training, reportedly tied to her now-failed-as-ever product line. Harry's legal team submitted Amex and HSBC statements, cross-referenced with Archewell corporate spending logs, indicating that these charges had been funneled through Foundation sub-accounts. In a sworn deposition leaked this morning, a former Archewell accountant claimed invoices were retroactively labeled as brand representation or philanthropy alignment, but we were paying for luxury handbags and international press escorts. Meghan's team has denied wrongdoing, asserting that all expenses were tied to identity expansion, post-Megxit career continuity, and protection of public image. Adding fuel to the fire, a redacted document from the U.S. Treasury Financial Crimes Enforcement Network, FinCEN, confirmed the existence of 2 Cayman Islands accounts associated with a company called Echo Clover Limited, registered in the British Virgin Islands under an Archewell-aligned legal trustee. The accounts allegedly received $890,000 in transfers from Dubai-based event organizers between August and December 2025, none of which were disclosed in Archewell's tax reports or Meghan's individual declarations. Meghan's spokesperson called the filings defamatory, based on outdated structuring, and irrelevant to custodial arrangements. But the palace has reportedly forwarded the documents to the UK's Serious Fraud Office for evaluation under the 2023 Crown Transparency Statute. Behind closed doors, Prince William and Princess Catherine are no longer just symbolic figures in the crisis. On February 13, William convened a private session with the Royal Household Financial Office, directing that all Windsor-linked assets, co-managed by Harry, including trademarks, royalties, and speaking engagements, be placed under independent escrow review. Princess Catherine, meanwhile, was photographed entering Highgrove legal chambers, carrying sealed documents believed to relate to royal child welfare provisions. Sources close to the legal team confirm she is preparing to submit a co-statement of logistical capacity, effectively declaring her readiness to serve as an educational and emotional guardian for Archie and Lilibet should full custodial reassignment proceed. A source within the palace described the atmosphere as quietly strategic and emotionally resolute. In an unprecedented move, Princess Anne convened an emergency summit on February 14 with senior members of the International Family Law Commission and legal scholars from the Hague Convention on the Civil Aspects of International Child Abduction. Held at the Windsor Legal Institute, the summit's primary goal was to pre-authorize cross-border guardianship enforcement mechanisms in case Meghan attempts unauthorized international relocation or uses diplomatic channels to block UK oversight. A delegate from Canada reportedly told The Telegraph, "This is no longer about divorce. This is about building new precedents for what happens when royalty, brand, and law collide across continents." The summit concluded with a joint draft resolution titled, "The Sandringham Declaration on Sovereign Minor Protections." Its full text is expected to be published on February 20. In a dramatic twist, Meghan's legal team submitted a preliminary inquiry to the United Nations High Commissioner for Human Rights, claiming that Britain's hereditary institutions are attempting to erase a woman of color's maternal rights through judicial colonialism. The inquiry, addressed to Geneva, is non-binding, but its very submission signals that Meghan intends to frame the entire dispute not as a custody matter, but as a global civil rights issue. Palace officials declined to comment, but insiders say the monarchy is preparing a cold, institutional, and legally bulletproof rebuttal. As the fifth day of legal escalation unfolds, what once appeared to be a custody case has fully matured into a high-stakes struggle for control of a media empire, a digital dynasty, and the narrative future of two royal children. Today, the conflict reached a new crescendo, as lawyers for Prince Harry filed an emergency injunction to block Meghan Markle from unilaterally dissolving Archewell Foundation's digital archive, a collection of assets estimated to be worth over $37 million USD in branding, licensing, media development rights, and unpublished IP, including footage, personal interviews, and high-profile podcast drafts involving Prince Archie and Princess Lilibet. Meghan's legal team made a bold request in court this morning to retain exclusive control of Archewell's digital servers, admin passwords, and editorial access, arguing that her creative input represented over 70% of the foundation's branded narrative structure. In documents submitted to the California State Digital Asset Tribunal, Meghan demanded sole curatorship of all interviews involving the children, deletion of all draft content not contractually obligated to sponsors, ownership of any future revenue generated from image licensing tied to family likenesses. The Crown responded within hours through Harry's legal counsel, invoking the Royal Minor Identity Protection Order, RMIPO, filed jointly with the UK Digital Sovereignty Bureau. This prevents any monetized reuse of royal child imagery without consent from their legal custodians and the Office of Royal Media Ethics. A confidential note from Princess Anne's office, leaked by a royal household staffer, simply stated, "The Crown will not allow the children's faces to become an exit strategy." Forensic accountants commissioned by the court submitted a preliminary ownership report revealing Meghan and Harry each held 48% equity in Archewell. The remaining 4% was assigned to a third-party philanthropic trust affiliated with Spotify Cares under a limited liability clause. However, Meghan's counsel is now arguing that emotional authorship entitles her to a controlling interest in all public-facing platforms. The legal term she invoked, narrative equity, has triggered alarm across media law circles, as it could set a precedent for personal branding litigation across entertainment and nonprofit sectors. Archewell's original Articles of Incorporation, 2020, are now under judicial seal, pending a full intellectual property arbitration set for the 11th of March 2026. While Meghan's team had long counted on the loyalty of progressive U.S. media outlets, recent developments are proving volatile. Headlines today revealed growing unease. New York Magazine, "The brand that ate the baby, when legacy becomes leverage." Washington Post, "Custody meets capitalism in the House of Windsor." CNN Opinion, "How Meghan overplayed her hand in the court of public emotion." Social media sentiment is also turning. A viral tweet from @UK Royal Watch read, "She demanded privacy, then trademarked their names. The Crown demanded structure and gave them safety. Who's really protecting the children now?" Public support for the monarchy's actions, especially among younger UK and Canadian audiences, has risen to 68% in a YouGov Snap poll released at 7 a.m. GMT. Throughout this storm, King Charles has remained out of sight. Still recovering at Sandringham following an unannounced procedure in early February, He has delegated all decisions to Prince William and Princess Anne. And yet, insiders suggest the king may make a return not to the courtroom, but to the public stage. A televised message is tentatively scheduled for February 21, marking 1 year since his 2025 constitutional transition of duties. Sources say the message may touch on institutional stability, child protection, and the enduring values of sovereign neutrality. If delivered, this would be Charles's first official statement on the matter, and possibly his last before full abdication rumors intensify. In a final twist, sources confirm today that Archie and Lilibet have been relocated from Wolverton Cottage to an undisclosed site believed to be within the Highgrove security corridor. The move comes after Palace intelligence flagged multiple drone flyovers and cyber intrusion attempts targeting the children's new residence. All digital contact with the children has now been routed through the Royal Child Welfare Firewall, a multi-layered communications channel overseen by Duchess Sophie and Lady Louise Windsor. The palace has issued no comment. The final act of the Windsor-Sussex custody saga unfolded today behind tightly sealed courtroom doors, but its shockwaves rippled across continents. At exactly 10:03 a.m. PST, Meghan Markle entered the Santa Barbara Family Law Courthouse, flanked by 4 attorneys and a digital strategist. Her expression was defiant. She wore no royal jewelry, no Arcuel branding, just black slacks, a fitted blazer, and a calm, studied silence. Inside courtroom 4B, the judge presiding over the transatlantic custody case, Justice Maya Caldwell, a seasoned arbiter of international family disputes, called both parties to the table for a closed evidentiary hearing. What followed, according to insider summaries leaked hours later, was the emotional and legal dismantling of Meghan's final defense. Among the most damning revelations presented, a leaked exit strategy memo titled Project Mirror, recovered from a private Arcuel server. The file outlined Meghan's emergency relocation plan to Qatar, where she would allegedly enter a multi-year media development contract with an entertainment subsidiary of the Qatari Sovereign Fund, establish dual citizenship through honorary sponsorship, enroll Archie and Lilibet in a bespoke international school in Lusail, bypassing all UK and US custodial notification requirements. The plan, dated the 18th of January 2026, was reportedly never shown to Prince Harry, who discovered it only after court-ordered forensic IT analysis of Arcuel's encrypted servers. When presented with the memo in court, Meghan remained silent. Her lead counsel, Sherry Tilden, attempted to dismiss the file as an unsolicited brand blueprint, not an executable plan. But the metadata, including timestamps and tracked edits under Meghan's personal login, told another story. Back in Windsor, the royal family was already moving forward. At 2:45 p.m. GMT, Princess Anne chaired a final emergency session of the Sovereign Custodial Oversight Council, officially confirming Princess Catherine and Duchess Sophie will serve as permanent joint guardians of Archie and Lilibet within the UK. All Windsor-aligned properties, digital assets, and educational pathways for the children will fall under the Grey House Protection Act, ratified on February 17. Meghan Markle's name will be formally removed from any royal trustee positions or digital asset governance as of the 1st of March 2026. An updated Royal Gazette entry marked the occasion with clinical precision. Effective this date, all custodial, educational, and representational decisions regarding Master Archie Harrison and Princess Lilibet Diana are henceforth subject to sovereign oversight. The Crown recognizes no external claims until the minors reach majority age. As the court hearing closed, Justice Caldwell reportedly turned to Meghan and delivered one sentence that instantly flooded social media and news tickers alike. You cannot weaponize motherhood and reject responsibility in the same breath. Courtroom observers described Meghan's reaction as stone-faced, blinking rapidly, lips pressed so tightly they trembled. Prince Harry, seated beside his counsel, lowered his head, closed his eyes, and didn't speak. No victory gesture, no relief, only exhaustion. The judge then ruled the February 11 agreement would remain in effect as a permanent framework. All relocation attempts are prohibited without mutual consent. Custody would remain shared but managed by a third-party child welfare liaison appointed by both UK and US courts. Control of the @Archie Lilibet social media account was transferred to the Royal Child Welfare Trust. Meghan was ordered to reimburse $1.3 million USD in misallocated Arcuel funds within 90 days. All pending sponsorships using the children's image were voided, including contracts with a French luxury skincare brand and a Los Angeles podcast studio. The Arkwell Foundation will now be dissolved, with assets frozen pending distribution under charitable trust law. Meghan is barred from launching any entity containing the terms Arch, Windsor, Sussex, or Lilibet in any trademark, brand, or media product for 10 years. As the ruling was read, Meghan sat motionless. Her attorneys whispered. She blinked but did not cry. No cameras were allowed inside, but as she exited the building at 1:23 p.m., her face showed unmistakable shock. Outside, no Arkwell staff awaited her. No press conference. No black SUV with tinted windows. Only a mid-range vehicle driven by a private assistant. She left quietly, and for the first time since 2018, she left alone. Just after sunset, Prince Harry issued a handwritten statement, posted to the royal family website. "I will never be perfect, but I will be present. I will be a father before I am anything else." It was signed, Henry Charles Albert David. No duke, no prince, just a man with 2 children, and now, no marriage. The monarchy has closed its gates. Meghan Markle is financially constrained, legally bound, and globally scrutinized. Arkwell is over, custody is settled, and history will mark the 18th of February 2026 as the day the crown defended its children, not with anger, not with arrogance, but with structure, discipline, and enduring silence. The Windsor machine did not shout. It simply outlasted her.